All right. Hello, everybody. My name is Drew Tingstad. I'm an associate lawyer here at Beresford Booth. My practice is kind of split in half. I do some business real estate work on the transactional side and some business real estate work on the litigation side as well. And the reason I bring that up is because it's directly related to this topic that we're going to get in today, which is how do I get out of business with my business partner? A lot of people get into business with one other person, whether it be, an LLC, a partnership, corporation, and we get very excited at the beginning of that business endeavor because of all the possibility. And we don't stop to think about, well, what happens if something goes wrong? What happens if I want out of this? And primarily, the first thing that we want to do is think in advance. And this is my work on the transactional side. We want to be proactive to understand, okay, if it goes wrong, let's lay out our options. How can I get out? How can I make sure I get paid the fair value of my interest? Or maybe it's the contribution that I put into the company, something like that. And so that always and forever is going to be the primary option, which is let's plan in advance. Let's have a term in our contract that will lay out how we're going to do this. And this takes, a host of different forms. You can have a buy-sell agreement or a buy-sell provision in your contract. You can have a buyout provision in your contract, whether it's an LLC agreement, shareholder agreement, whatnot. But there's that on the, we're going to be proactive and kind of form what our buyout resolution or a buyout provision is going to look like in our contract before we even get going. And that takes a lot of foresight, but that is the primary option. Next, of course, if you go down this business road with your partner, you start butting heads, you're like, geez, I need to get out. Next thing, of course, is you just reach an agreement. Maybe we don't have a provision in our contract, so we just need to figure a way out between ourselves. And this can take the form, of a negotiated settlement, for example, where hey, I'll agree to, sell you, my business partner, my shares, my interest for X amount of dollars. But typically when you get to this point and you're already butting heads with your business partner, negotiated settlement can be really difficult. And so you have to kind of find ways to force your way out. Um, and that's really what this topic deals with is how do I get out of my business when my partner's not letting me? I feel like I'm stuck in this business because a lot of these LLC agreements or shareholder agreements have transfer restrictions where it doesn't let you just go sell your interest to a third party. Now, of course, if the governing documents of your business allow that kind of a transfer, you could go and sell your interest to a third party in order to get out. You want to make sure that there's nothing lingering, no lingering obligations that you would have to the company. But of course, that is an option if that option is available. But what happens when there's transfer restrictions where there's not an agreed provision in the contract that, lets me get bought out or get out of the business or buy out my business partner? What happens if I can't reach a negotiated settlement when I want out? And this is really what brings me to the root of this, which is on the litigation side, you can force your way out of your business through something called judicial dissolution. And depending on the structure of your business, this may take different forms. Judicial dissolution of a corporation looks very different than judicial dissolution of an LLC. And the differences are really in the legal standards. There's some similarities, but not too many. And what I want to focus on here today is judicial dissolution of LLCs. Most businesses that are formed nowadays are in the form of an LLC, so it seems most topical. And with judicial dissolution of an LLC, what the statute or the Washington LLC statute allows you to do is petition the court to have the court judicially dissolve the company, which means, hey, we're going to end this business and everything's going to get sold and everybody's going to get their interest in the company back, subject to if there are any creditors or whatnot. Of course, I'm oversimplifying here a little bit, but that's the general gist. And it's a curious question because it's a bit of a difficult standard to interpret in Washington. The statute is RCW 2515-274, and it provides two possible ways to judicially dissolve a business. Either the court has to determine that it's not reasonably practicable for the LLC to carry on business in conformity with its operating agreement, or the court has to find that other circumstances render dissolution equitable. And it's a difficult interpretation in Washington because there really isn't a lot of case law on the topic. There are some other jurisdictions, which we'll get into here in a little bit, that do dive into that not reasonably practicable standard. But in Washington, there really isn't anything interpreting it. There is a case that goes into the application of the statute. This is In Re Dissolution of Apogee Capital LLC, which was a Court of Appeals case that talked about how the statute applied to a particular situation. So while it may not have a whole bunch of precedential value in terms of its interpretive components, it is helpful to see it applied in practice. And there, in Apogee, a dispute arose between two members with identical 50-50 ownership interests, and one member wanted out and the other one didn't. And basically, because their operating agreement necessarily required consensus for major decisions. I mean, if it's 50-50, if one says no and one says yes, you can't reach a decision on how to operate the company. So necessarily, you need 100% of the ownership interests to vote yes in order for an action to be taken. And because the operating agreement required that consensus for certain decisions, this deadlock meant the LLC could no longer function or be dissolved. And what the Apogee court talked about is, hey, they couldn't even figure out whether to continue the business or dissolve it. And it got to the point, what the court did is they analogized to this impossibility standard of contracts. We have an operating agreement where we're supposed to carry on this business, but it's impossible for us to do so because we have 50-50 ownership interests and we can't reach an agreement on anything. So that case is helpful in the context of, two member LLC businesses, which a lot of businesses are, and figuring out how can one partner, one member of that business get out, and they can force their way out by saying, hey, look, we can't agree on anything. We've tried, the business can't move forward. I basically have no rights as a member because my business partner obstructs and says no at every turn. We can't agree to dissolve the business. Court, help us do it for us. So that case is helpful in terms of application. But then the next step is, okay, well, how do we interpret this not reasonably practicable standard? And the seminal case for this is Haley v. Talcott and Delaware law. And Washington courts often rely on Delaware law for its influential jurisprudence on interpretation of business entity statutes, much like we're dealing with here with the judicial dissolution statute. And they basically lay out, the Delaware court does in Haley, lays out three elements for reaching that not reasonably practicable standard in their own statute. But it's a really helpful analogy here in Washington. And that this is that, again, two 50-50 members carry on, their LLC. And how do we know if it's not reasonably practicable? How do we know if the court can judicially dissolve it? The first one is that you identify that the LLC has two 50-50 members. The second is that they're engaged in a joint venture, which more often than not is, always the case. And then there's the dispute. They must be unable to agree on whether to discontinue the business or how to dispose of its assets. And There's a sub element in the court's analysis as well, which is whether or not there is an out in the business, the governing documents in the LLC agreement. If there is a buyout provision in there and a party could simply use that, the court won't need to go into this analysis because they can just point you there. But of course, we're at this point because there really isn't one. There isn't a provision that we've proactively created. And so the Delaware case law is really helpful. It talks about how if there's, it's unrealistic for two business members to carry on in business together. You can think about, okay, what if me and my spouse are in business together and we get a divorce? Well, it's not realistic that we're going to carry on in the business. How could we? We're antagonistic to each other, or two parties who are embroiled in, litigation, and they clearly don't like each other. Well, that's going to be an indicative factor that these parties just aren't going to be able to get along. And so we can take some of this Delaware case law, and it's really important for lawyers to understand the Delaware case law and its, interpretation of these business entity statutes because it is applicable here in Washington. Washington, again, relies on Delaware's influential jurisprudence on these matters. And so at the end of the day, when you have a LLC with two 50/50 members, there is a mechanism for the court to force the parties to separate, force the sale of the business, and let everybody go on their separate way. Um, and so it's just really important for people to consider these when they get into a business with one another. We all like to think that it's, sunshine and daisies when we start a business. And, Lord willing, that is the case. The business can carry on, you can make a bunch of money and you never have an issue. But it is always important to plan proactively for potential issues like what happens if I want out. And there's a bunch more case law on all of this stuff. But at the end of the day, no one wants to be embroiled in this litigation to force the court to decide. So it's generally best to be proactive. Let's have a agreement on how we want to handle deadlock. How do we want to handle, when one business partner wants out and the other one doesn't. So all of this is just helpful to take into consideration. And if you ever have any questions about your business, or if you ever want to get out of your business with your business partner, feel free to give us a call here at Bears for Booth. Thank you.